Hello, everyone, and welcome to the Legally Speaking podcast. I'm Ala.
And I'm Gali.
And today we have another episode on energy law, but this time we're exploring the international trade of hydrogen in the European context. And today we have another very special guest with us. Would you like to introduce yourself?
Yes, thank you very much for the invitation, Ala and Gali. So my name is Sebastian Noël. I'm 30 years old, originally from Belgium, and I live and study in Finland, at the University of Eastern Finland.
So can you give us a brief of what your research is about?
Sure. So I basically research on the compatibility of EU energy, environmental, and transport policies with the World Trade Organization using hydrogen as a case study.
Okay. And in your background, you did say that you chose Eastern Finland University to conduct your research with. Why?
Well, for various reasons. So I did 2 master degrees in law, one in public international law, another one an LLM in EU law. Then I went to the US for an internship at a law firm, and I quickly realized that it was not my cup of tea. And once I came back in Belgium, I was just looking for jobs, and one research traineeship was offered by ELSA, the European Law Student Association, which was in Joensuu, Finland. And there I met researchers working on energy law, international environmental law, and that sparked my interest.
Oh, wow. And now you're visiting Groningen, right?
Yes, so after 3 years of the PhD in Finland, I've applied for a research visit in the Netherlands, but I initially already wanted to come here when I applied for the PhD in Finland, because I knew the Groningen Center for Energy Law and Sustainability was one of the really best in Europe, so that made sense for me.
Yeah. And can you give us a brief of what your doctoral research is about?
Sure. So in a nutshell, I'm researching the international trade rules that affect EU energy policies on hydrogen. So one of the fundamental questions is the issue of like products. So are different production processes of hydrogen, so hydrogen produced with fossil fuels, so using natural gas, coal, petroleum, similar to hydrogen produced with renewable energy, for example, wind and solar power, through a process called electrolysis.
Okay, let's step back a bit. What is hydrogen?
So, yeah, thank you for clarifying it. So hydrogen is a secondary source of energy. So you have normally primary sources of energy. So you have, for example, petroleum, coal, natural gas that will have to be converted into a secondary source. But hydrogen is very versatile because you can obtain it from fossil fuels that I just mentioned. You can also obtain it with renewable sources, so from biomass or from water, and you will split the molecules, the H2 and oxygen, with electricity. But then again, electricity can be generated from different sources. I'm not going to cover that because it's a bit more complex. And once you obtain the secondary source of energy, hydrogen, you will then have to use it either as an energy carrier in the transport sector, for example, or as a chemical feedstock in the production of ammonia, for example.
Yeah, and so what is the role of hydrogen in kind of alleviating or, say, combating, alleviating environmental concerns and promoting climate change mitigation?
Right, so the great advantage of hydrogen is it does not emit greenhouse gas emission at the point of use. However, the production of hydrogen can be very different, because if you produce hydrogen with fossil fuels, so from natural gas, you have this conversion technology called steam methane reforming. With coal, you have coal gasification, and these processes generate a lot of greenhouse gas emission. But then you can also obtain hydrogen with, as I said earlier, renewable energy. So in that case, with water electrolysis, and the electricity has to come from renewable sources, then it does not emit greenhouse gas emission. You also have hydrogen produced now with nuclear energy. So same electrolysis processes, but the electricity comes from nuclear energy, uranium. And in that case as well, it does not emit greenhouse gas emission, but nuclear energy has its own challenges.
All right, let's explore international trade and energy law a bit more. Can you give us a brief on what the World Trade Organization is and what are the main principles of it?
Sure. So the World Trade Organization is an international organization that was established 15th of April 1994 and succeeded the 1947 General Agreement on Tariffs and Trade. So this international organization is composed now with a main treaty, the WTO agreement, and several annexes covering the trade in goods, services, intellectual property rights. The main principles of the WTO are, for example, non-discrimination, which we'll cover later on, I hope, reciprocity. So because countries bargain, they've bargained over the years different tariffs to reduce in order to promote free trade of goods. So reciprocity, if one country agree to lower its tariff, it expects other countries to do the same. So that's what reciprocity is all about. You also have principles of sustainable development and differential treatments for developing countries.
All right, and could you tell us why these rules are relevant?
Right, so if you look at the WTO and its annexes, you won't find a single annex that deals primarily on energy. One of the reasons why historically international trade in energy was occurring outside the WTO system or even the GATT system, and it's only when major oil-producing countries acceded to the WTO that energy was integrated in international trade rules, which now have general application. So that you don't have any specific sector, at least in the trade in goods, excluding energy. So you can cover fossil fuels, renewables, nuclear as well. So, and these rules will be relevant for energy law because, especially in the GATT, they can provide a level playing field. And I mentioned earlier the principle of non-discrimination. So if countries decide to restrict the use of fossil fuels, well, other countries can claim, well, this will discriminate against my the competitive opportunities for my own products. So basically, those rules will govern the rules of trade.
Also, just a follow-up question to that, or a side question. You mentioned the GATT a few times. Could you briefly say what that is and maybe how it's different to WTO? I mean, you've already mentioned that, but just...
Right. So the GATT historically was the main agreement for the conduct of international trade, which was adopted in 1947, all the way up to 1994. There were successive rounds of negotiations that aimed to lower tariffs, but also to integrate other disciplines, which were called during the Tokyo rounds of negotiations the codes. So they were not per se legally binding, but there were principles that whereby WTO members wanted to advance on other disciplines as well, such as technical barriers to trade, trade in services, intellectual property rights. And once the WTO was set up in 1994, so the GATT of 1947 remained and was incorporated in the WTO, along with other previously called codes that are also now annexes and legally binding for the members.
Oh, okay. So you mentioned the non-discrimination obligation earlier. Could you tell us what that's about, please?
Sure. So the non-discrimination principle is an overarching WTO principle that occurs in different annexes of the WTO agreement. So you can find it in the GATT, but also the GATT, so the trade-in services, subsidies, technical barriers to trade, and so on and so forth. So it's very overarching pillars of the WTO system. And basically, it covers the most favored nation obligation and the national treatment. So most favored nation prohibits discrimination against third country imports of like products of different origins. So let's say European Union wants to, for example, grant or cut tariffs for cars 20%, and will grant that tariff cut to United States only. That will be a violation of MFN, because if it reduces its import tariffs, it will have to apply to all other WTO members on an MFN basis. There are exceptions to that principles, but the basic rule is that you apply equal treatment to other WTO members. National treatment is the prohibition of discrimination against imported products versus like domestic products. So again, and this will apply in terms of internal taxation or internal regulation.
Right. Sorry, just to briefly cut you off, to clarify, could you tell us what a like product is? Is it more so just products that fall under the WTO perhaps rules and the products that they manage, or could you tell us what that is? Cause
sure. So the like product is a very tricky legal term. So it's one essential conditions for the application of MFN and national treatment. So it determines whether or not you can apply, whether or not WTO members can differentiate certain products.
Mm-hmm.
So if products are not to be found like, then surely you can discriminate. But if they are like, then you cannot. So like product, it is not defined in the GATT itself. So you have to look at the case law. And you have different criteria that were conceptualized in the border tax adjustment, so a very old case from the 1970s. And the traditional criteria are the physical properties, nature and quality, and uses, direct classifications, and the consumer states and habits. So these criteria are not treaty mandated by the GATT or other annexes. They are not necessarily mandatory, but they are useful tools for WTO members and the panels to assess whether or not products are like.
Now, since we do have a good overview of what the WTO is, as well as its relevant rules and, well, related, say, agreements, could you probably recall some of the relevant legislation that is important for research? Let's say, what is the Fit for 55 EU package?
All right, so the Fit for 55 package is the EU's current national determined contribution. So it's a commitment that the EU put forward in its obligation under the Paris Agreement. And in a nutshell, the Fit for 55 package was submitted by the Commission on the 14th of July 2021, right? And it aims to reduce greenhouse gas emissions by 55% for 2030 compared to 1990s level, and aim and also achieve carbon neutrality by 2050. The Fit for 55 package contains a series of legislative proposals, some of which have now become EU law, such as the revisions of the Renewable Energy Directive, the CBAM regulation, the revised ETS, for example. ETS stands for Emission Trading System.
And that was a lot of legislation to deal with, so maybe let's focus on the first one that you mentioned, which is the Renewable Energy Directive. What is that?
Right. So now we're talking about the RED III because it's the second revision of the Renewable Energy Directive that was first adopted in 2009. So the current objective of the Renewable Energy Directive is to promote the Union's overall renewable energy sources use by at least 42.5% and 45% as a desirable outcome, which can be achieved with either bioenergy, electricity, or renewable fuels of non-biological origins. So then you will find renewable hydrogen, for example.
And so,
sorry if I just cut you off.
Don't worry about it.
The Renewable Energy Directive, the new Renewable Energy Directive, increased the renewable energy targets in transport. So now the target is at 29%, but it also introduced new targets in certain sectors that were not previously addressed, such as industry and also heat and cooling.
Okay, so RED III is more expanding.
It's more comprehensive.
Scope, right?
It's
okay.
wider in scope. Yes.
Right. So knowing all of this, say the WTO as well as the relevant EU legislation that we very briefly talked about earlier, what are the most fundamental questions that you found regarding the international trade in energy?
Sure. So I will just limit my answer to the trading goods. So addressing the GATT here. And the first fundamental question is like products, which I mentioned earlier, determines the application of MFN and national treatment. So in terms of hydrogen, you can ask yourself, can we differentiate hydrogen based on the product or the production processes? As a product, you cannot really, because it's the same molecule. So whether it's produced from renewable energy or fossil fuel, hydrogen H2, it is the same molecule with the same properties. But when it comes to production processes, you probably have heard of this color-code terminology: blue hydrogen, green hydrogen, brown hydrogen, gray hydrogen. So brown hydrogen and gray hydrogens are mostly produced from unabated fossil fuels. So fossil fuels without any carbon capture and storage technologies. So steam reforming of natural gas or coal gasifications. These are complex conversion techniques that I will not explain here, but it's basically unabated fossil fuels to produce hydrogen. Blue hydrogen uses carbon capture and storage or utilization, so you reduce the greenhouse gas emissions into the atmosphere. Green hydrogen is produced from renewable electricity reacting with water to separate its molecules. So my argument is we shouldn't look at hydrogen as a product itself, but look at the production processes. And this has raised a lot of controversial debates among trade lawyers, and also within the WTO institutions as well. A lot of WTO members disagree with the process-based distinctions. The WTO Secretariat is also on that side as well. But certain countries, such as the European Union, are more favorable towards process-based distinctions. And the relevant case law that I'm using in my research are, for instance, the EC asbestos, because, well, the PPM, so let me explain perhaps the PPM questions, process and production methods. So it is a way to produce certain goods in terms of the raw material, which involves certain raw materials and technologies. So the PPM can be either inherent to the product, So you have, for example, food additives or a certain molecules for cigarettes. So it is found in the product itself. But the ppm can also be external to the product. Greenhouse gas emission is a good example of that. So once you produce electricity or hydrogen, regardless of the primary energy source that you use, which then will generate a greenhouse gas, the final product, electricity. So when you look, first of all, you cannot look at the electrons, but you cannot differentiate electricity produced from coal or from wind power. Same with hydrogen. And that ppm is external to the product. So the relevant case law, again, are EC asbestos. At least it contributes and opens the discussions further. You have also the Canada Renewable Energy case that was decided in the context of electricity in 2013.
So essentially, are you saying that there's no, say, ultimate answer for like products? Can countries still restrict the use of fossil fuels to produce hydrogen?
So the reason I'm saying there's no ultimate answer is because so either you want to differentiate products based on, there are two methods that you can use, either a more economic or objective method that will then result to statistics or cross-price elasticity of demand. And this method has been conceptualized in the Japan alcoholic beverages in 1996, and this was mostly in the context of internal taxations. But that does not answer the ppm question. So for the ppm question, the relevant case, the leading case was the EC asbestos. But then also, so if I can just explain perhaps that case, because I'm not sure everyone's familiar with it. So in 2000, you had a French ban on asbestos fibers, which were imported from Canada. So France and European Union imposed a ban on that type of products. The reason why the ban was for public health grounds, because the toxicity of the asbestos could cause risk of cancers and diseases. So in that case, the asbestos was inherent in the product. So product-related ppms. And the appellate body emphasized the product characteristics as well as consumer preferences as a way to differentiate products and ultimately not consider them as like products. That case reopened the ppm question that was initially conceptualized in the tuna dolphin cases in 1991 and 1994, which restricted the use of ppms in the national treatment obligations. But this case were never adopted under the WTO or the GATT system. So if they're not adopted, they have less legal relevance. But nevertheless, the legal debate was still very present in the doctrine. And there are a lot of opposing arguments still to this day on this issue of ppm. The understanding is you can use non-product related ppms in the like product determination only if it has a determining impact on the consumer's preferences. And consumers need to be informed, but also you need to establish that in practice they do differentiate based on that ppm, so greenhouse gas emissions and so on and so forth. But because I, in my research, realized that this question doesn't have an ultimate answer, I want to look at a more explicit legal basis, which is Article 20 of the GATT, so the general exceptions provisions. And the most relevant provisions are Article 20. So Article 20 works in a two-tier system. So first, you need to justify your measure under one subparagraphs of Article 20 A to J, which can cover the protection of public morals, but also measures that can be necessary to protect human, animal, plant life or health, or conservation of exhaustible natural resources. So if the measure is fulfilling one of those general exceptions, then you need also to justify under the chapeau the preamble of Article 20, and that deals with how the measure is applied. Is it arbitrary? Does it generate an unjustifiable discrimination? How does that relate with due process? Mm-hmm. Right. And the relevant case law. So in itself, PPM are legal. They can be justified under Article 20. They're not, even if they are unilateral measures, they're not by themselves illegal under the GATT. And that was recognized under the U.S. Shrimps case in 1998, and U.S. gasoline after that. So you have a series of cases that confirm that. But the most complex issues under the chapeau, so the arbitrary aspects.
And so knowing all of these relevant cases that you've done in your research, what approach have you taken then in crafting your article?
I just took a very traditional legal dogmatics approach. Mm-hmm. So I interpret the relevance rules of the GATT in the context of hydrogen. Mm-hmm. It's a treaty interpretation and use of the case law. Mm-hmm. No interviews or empirical research in my study.
Purely on, say, understanding and what you've analyzed from these relevant cases and everything.
Yeah. I mean, I could do it, for example, if I were to look at consumer preferences. And I think it will enrich my research if I were to either conduct statistical